So when the call first came out for public inputs from the Toronto Police Services Board, Kristen Thomasen, who unfortunately couldn't be here with us today, reached out to Kate and I to see if we wanted to collaborate on the submission. And when the three of us started talking about what it is that we wanted to do with this particular submission, I think the commonality between Professor Thomasen's work at UBC, the work that I'm doing with LEAF, and then the work that Kate has done with Citizen Lab is that we really all are interested in this idea of human rights and substantive equality. And so we wanted that to be a fairly central focus of a submission that we made to the police board. And I'll talk a bit more later on in our conversation about what we mean when we're thinking about substantive equality and artificial intelligence and some of the issues that come up with that. But ultimately in our submission, the main things that we're urging is for the police board to take, to really center their decision-making on precaution, substantive equality, human rights, privacy protections, transparency, and accountability. And in doing so, in our submission, we really encourage them to look to equality seeking groups, people who are experts in human rights, people who are experts in equality, and especially people who are experts in AI, both in the development of this policy and in the future implementation of it, both in deciding when to adopt artificial intelligence, if at all, and also how to implement that. And a major key piece in that is that we wanted to emphasize that, the use of AI in all these different circumstances isn't inevitable. This is always a choice about when to use AI or not. And of course, there will be some AI that police boards will be using. But what we wanted to encourage was really this kind of thoughtful and ongoing assessment about whether AI is necessary to be used at all. And then if it is determined to be used, how to use it and what procedures need to be in place to ensure that equality and human rights are protected in that process, which I think is something that everyone wants to happen as we see the future of AI and its use in policing. So that's a real kind of basic introduction to the submission and how we got together to write this, but I'll pass it on to Kate, who really is the expert in the room on this topic. She was one of the main authors on the Citizen Lab report and has been thinking incredibly deeply about this. And so I'll pass it on to you, Kate.
Thanks so much for that introduction and overview of some of the really interesting and thorny issues that are brought to bear and come into focus when looking at this draft policy from the Toronto Police Services Board. In terms of the report that Suzie spoke about, To Surveil and Predict, that is a report that was a joint publication in 2020 of the Citizen Lab, as well as the University of Toronto's International Human Rights Program. And it was a report that took on quite a few important issues in the larger landscape of algorithmic policing technology. And I'll talk about that in a very high level way, just to situate where within that landscape this draft policy is entering and what has predated the draft to date. So one of the primary outputs that came from the To Surveil and Predict report was that there was a fact-finding component of our research, in part because even for myself as a practicing criminal law barrister, I only had a very surface level understanding of the extent to which algorithmic policing technologies are being used in Canada. What we did know as researchers is that those types of technologies were being experimented with and had even been adopted at citywide or broader levels in other countries, but we didn't know to what extent that was happening in Canada to date. And so one of the important takeaway findings that we arrived at is that algorithmic policing technologies are here in Canada. In order just to detail that finding in a slightly more useful way, without getting into the wholesale review and summary of the report itself, which I can commend to you. I'll just put on the screen a visual that helps break down what some of the different types of algorithmic policing technologies are. And on the left-hand side of the screen, you have a category that is often referred to as predictive policing. And then you can have other types of technologies that rely on algorithmic programming to facilitate a range of different types of surveillance activities. And what's common throughout these technologies is that there's an algorithm at work, but to what extent it is sophisticated, it falls on a spectrum. And the ways in which it uses data and generates inferences also falls on a spectrum. And so on the left-hand side, with the predictive policing programs, we have a couple of different types that we know exist in the world. Some are location focused and some are person focused. So by that, we're talking about an algorithm that's designed to attempt to draw generalized forecasts about the future. Some of those programs are designed to try to generate inferences about locations, such as in a city where something is likely to happen. Other types of programs might look at a particular individual profile, or more often actually groups of people that share common characteristics in society and generate guesses or estimates about what's likely to take place in the future of those groups of individuals. The uptake of algorithmic predictive policing is not on the same scale as it is in Canada for algorithmic surveillance. I mention all of this because the Toronto Police Service itself was one of the services that we were conducting research about. And at that time, it was clear that they had collaborated with a private sector organization, a data analytics company called Environics Analytics. But the extent to which that and another program from IBM called Cognos Analytics was being used by the Toronto Police Service. At the time of our research, we interviewed a representative from the service, and their response was that they had no plans at that time to implement a predictive policing program in the immediate future, and that they hadn't engaged with any technology vendors for that purpose. But they did say that they were considering implementing a location-focused algorithmic policing program in the future if they have the resources and if there is alignment with federal or provincial governance strategies, among other factors. And so what it appeared to be the case is that there would potentially be an expansion of the use of a predictive policing model. The timing of that, the scope of that was not clear at that time. We do know that the Vancouver Police Department has introduced a location-focused predictive policing program. And there's another program in Saskatchewan that's a person-focused program. In terms of the, and that's, I should say, in development. In terms of the algorithmic surveillance technologies, on the screen that I had shared, there's examples given of a range of different types that we already know are being used: automated license plate readers, social media surveillance, chat room scraping tool, facial recognition that includes Clearview AI, as well as a database, a different type of facial recognition technology that's being used by Calgary and Toronto in particular, as well as potentially others, and social network analysis. So at the time of that research, again, it wasn't clear the extent to which the Toronto Police Service was continuing to use platforms such as a social media surveillance or social network analysis. The representative that we spoke to said that they couldn't speak to that because they weren't in the department that would be able to answer that question. But What can be concluded from that fact-finding research that we embarked on is that these technologies are certainly here. It's not entirely known the extent to which the Toronto Police Service is using them. We do know they're using some forms of technologies, and then there appeared to be an indication that there's an expanded scope potentially when there's a regulatory structure that would pave the way for that, which is where the draft policy appears to potentially be relevant to that conversation. We know that the draft has arrived in a context in which there is that potential interest in expanding the scope. And so for me as a researcher, knowing that there are other programs elsewhere around the world that have actually been implemented at an earlier stage and have even been abandoned because of some of the risks around these technologies and their experimental nature and some of their human rights risks. They've actually been abandoned, such as in American cities where they have been introduced at earlier stages. So knowing that those are real risks that can have real impacts on the success of these programs and their viability, I think one of the big questions, or a very basic question about this draft policy, is whether it will be sufficiently attuned to that level of risk such that a different path will be seen than some of the cities in the United States where they've introduced predictive policing programs but unsuccessfully. And so with that, from what our report, we came to a number of conclusions on the human rights risks. One of the most important areas of human rights danger that we identified in our research is equality rights issues. And I'm going to ask Suzie to take over from there to talk more a bit about that, given it's such an area of joint interest between our organizations.
Great, Kate. Yeah, thank you. Thank you so much for that. I think it's so useful to have these like real concrete examples of, what does algorithmic policing look like? What are these things like license plate readers, social media scraping? These are all things that we can kind of sink our teeth into. So for the next portion, I'm gonna speak mainly to some of the equality issues that come up, and I'll speak to some of the issues that I think we're more familiar with when we're thinking about AI and algorithms and equality, which of course is kind of the potential for embedded bias, the potential for flaws in artificial intelligence that lead to discriminatory outcomes. But two other pieces that I think are important for us to highlight, which we did in the submission, was also having a conversation around, even if we have perfectly accurate AI, it can still lead to discriminatory outcomes. And I think that's something really important to take into consideration when we're thinking about the uses of AI. It's not how do we fix the AI, but it's whether the AI is actually being capable of being used in non-discriminatory ways. And then the final piece that I'll speak to is a bit about this idea of how you get public buy-in to AI. And one of the things that we often see when we're looking for increased police powers or new uses of technology is sometimes they'll hook a bit of an equality lens onto it. And we want to push back on that a bit around this idea of co-opting equality issues in order to promote additional police powers or police technologies that might not necessarily benefit vulnerable groups particularly, or more marginalized groups more generally. So of course, anyone who's read anything on AI is familiar with the reporting done by ProPublica. We know that AI can replicate and amplify bias. For any of you who are in the room who might not be familiar with that report, there was a program called Compass that was assessing recidivism for sentencing reports in the United States. And ProPublica dug deep into the statistics of what was coming out of this and found that there was indeed racial bias that was categorizing certain Black individuals as higher risk than they should have been labeled. And then on the flip side of that, some non-racialized white individuals were then categorized as less high risk than they should have been. And basically what that showed is that if you put bias data in, you can get bias data out. or even if the data isn't biased, if the AI picks up on particular aspects of, of what might be more kind of social aspects, like if someone lives in a neighborhood, they might start picking up those trends on saying, oh, if you live in this neighborhood, you're much more likely to be labeled as high risk. And so then it might just start adopting this type of thing as a factor. And so AI can kind of amplify bias and not even just replicate it. And outside of the policing context, we've seen things like artificial intelligence. I forget which company it was at. It was one of the Google, Facebook companies was pulling through all of the different applications for, I believe, engineering jobs. And then at a certain point, they started not selecting women, and there was no indication in the instructions to the AI to not select women. But over time, it had kind of picked up these norms in the job applications that had been successful in the past that were predominantly men, and started picking up on that and producing that. And other examples of AI that were identifying the difference between genders and identifying pictures of women and pictures of men. And in one program, it started recognizing that women are more often in kitchens. And so instead of identifying the body in the image, it started identifying the background in the image and saying anyone who's in a kitchen must be a woman. And so you can see these kind of interesting ways that if AI isn't monitored and corrected, that it can actually amplify bias, which of course in a policing consideration, when we're thinking about the risk of people being arrested and having their liberties put at stake, this is extremely significant. Often there's this question around data sets as well. And when we're thinking about the data sets that police forces might be using, they'll often be using historic data from policing. And what we know here in Canada from research that's been done is when we think about the records that police have on file on things such as missing and murdered Indigenous women or victims of sexual violence, we know that there has been some issues around gender inequality in both the evidence collection and investigation of those cases. And so if the police boards were to rely only on that type of data, only on that data set, even though it might be a complete data set from the police, because there's these other underlying issues of discrimination and equality in evidence collection and investigation, if that's the main data sets that are being relied on, again, there's risk that this historic bias can then be found in the future determinations of what's coming out of the AI. And then one final point before I move on to another topic is also the idea of categorizations. So even when we're thinking about how do we label things within the algorithm, are we dividing things in discriminatory ways? So a very clear and easy example to think about is that you might have AI that's only given the opportunity to identify whether someone is male or female. And so they'll only be looking within the gender binary. But of course, what we know is that there's many people who identify as non-binary or may have some other gender identifier. But if that label doesn't even exist within the AI, then there's a potential for people to be mislabeled or excluded, even from the analysis that the AI is doing. So these are some of the issues that come up directly with equality in AI, and that's in general for AI, but also, of course, appears in policing. In the United States, where it is more common to use these facial recognition technologies, we've seen at least 3 cases where people have been misidentified by facial recognition technology, which has led to their actual arrest. And these are significant impacts on people's lives. One case was a New Jersey man named Niger Parks. And in that case, someone had shoplifted some candy from a store and then fled in a car that hit a police car. And they used this driver's license that was left behind from this person to do a facial match and misidentified Mr. Parks. And Mr. Parks was arrested. He was in jail for 10 days. He had to pay around $5,000 to defend himself. And during that time, he seriously considered pleading guilty because he had 2 other previous offenses. And in the jurisdiction that he was in, for your third offense, the chances of you going to jail for 10 years or longer, regardless of what the offense is heightened. And so even though he knew he hadn't committed this crime, at one point he had actually considered pleading guilty because he was so afraid of what had happened. But eventually, you know, the case was found that there wasn't enough evidence for it because he could show that he was in a different area when this crime was committed. But you can see the high risks that exist when flawed AI is being used by police. And these are only the early days, and these are the only reported cases that we know of. So the second point that I wanted to talk about was this idea of accuracy solving the equality issues with AI. So the examples that I gave before, of course, if we had perfect facial recognition, it would always properly identify the right person. And if we had incredibly accurate AI systems, it would never misidentify a person in a kitchen as being a woman just because women are normally in kitchens. You know, it would perfectly identify the person or the object or whatever is in there or whatever the AI has been trained to do. But even if we have perfectly accurate AI systems, some of the things we want to question is, you know, what's the outcome of using that AI? You know, so we might require mass surveillance in order to have this perfect AI system that impacts our privacy rights. We may end up surveilling over police communities, which we know here in Canada, Indigenous people in particular are extraordinarily overrepresented in the criminal justice system. We know that Black people in Canada are often overcarded, you know, and have extra interactions with police. And so if you have this perfect AI system that's then identifying every single crime that's out there perfectly, we might end up over-policing these very groups that are already being over-policed. And I think no one wants a perfect system where every time any sort of misdemeanor or any sort of minor crime occurs, that you want the justice system involved. You know, there's discretion in all of these things, but accuracy doesn't solve the problem of inequality. It can still replicate existing discriminatory practices. And then one thing that I've seen in my research, which is an unfortunate thing and something that I don't think policy can necessarily fix, but is a reality of the misuse of technology by members of the police force, is one thing that we have seen is that when there are members of the police force who may be perpetrators of domestic violence or may be stalking their ex-partners, it's been documented that multiple police officers will use the tools that they have available to them through their profession as a way to find information about their exes. You know, and so when we think about this misuse of technology already existing, the risk that it then puts to other people is also amplified if there's police misuse of artificial intelligence. And then the final point that I want to bring up is this concept of co-opting equality concerns to advocate for police use of algorithms and AI. And often what we'll see is that people will bring up examples that are very compelling for why we should use AI, that are very sympathetic, particularly in the circumstances of women and children. And we'll often say, you know, we can use this AI to find missing children. You know, we can use this AI to identify perpetrators of sexual assaults. You know, we need this AI to be able to do our jobs really, really well. And I think one of the concerns there is that it puts you in a position to say either you're willing to accept, you know, all of the AI, or you're not willing to help these really vulnerable people. And I think it's a bit of an unfair argument that is sometimes made, and it puts people who are in equality-seeking groups in a difficult position, particularly when we know that certain forms of facial recognition technology may be used in ways that actually, you know, perpetuate discrimination within their community and bring in increased policing into their community. And so it puts people in this difficult position. So when we're thinking about why we want to use artificial intelligence in policing, I think the messaging around that really needs to kind of avoid co-opting equality issues as a way to legitimize AI. Because the final risk before I pass things back on to Kate too is that if we do that and we say, okay, so for missing kids, we need it. because we always need to find missing children. And it's so important that we can use this technology to identify children in these images and go find them. But then that gets approved. And if that gets approved, then there's the potential for scope creep. So saying like, okay, well, if we're already using it here, can we just use it a little bit over here and then a little bit over there? And then there's the potential for it to kind of spread and be used in other areas where maybe it may not make as much sense. And so those are just some of the equality issues that we thought were really important for the police board to take into consideration when they're thinking about, you know, how to use AI, how to approve it, and how to do assessments as they decide whether to use and to continue to use algorithms in AI. But Kate, I'll pass it back to you to speak a bit more precisely about like some of the actual recommendations we had and some of the accountability issues that we had brought up in the submission.
Mm-hmm. Thanks. So what I would say just before getting to that topic is that just some general comments about the draft policy and how it works. So we have a first really important general feature of the draft policy that I would start with, because it's important and it's quite separate from some of the other issues, which is that the draft policy itself does not apply to the existing AI technologies that are being used by the Toronto Police Service. And one of the important recommendations that we've made, particularly given what it has been learned about what is already being used by the Toronto Police Service, including notably facial recognition technology and some of the other platforms where we know less about how those platforms are being used. It's so important that we have, if we're going to have an important policy document that puts meaningful guardrails on risky technologies, they should apply uniformly to all of those technologies, including the ones that have predated the draft and when it may come into force. The other important overarching feature of this draft policy that I think is important to understand, and I don't actually have access to the chat, but if you haven't found the copy of the draft policy yet, it's published on the Toronto Police Services Board website, and you can access the download of the draft as well as sort of a basic primer on what their consultation process has been so far. If you Google that, like the TPSB and AI, you should get that pretty quickly. But I'll just explain one of its architectural characteristics, which is that it creates a number of categories of risk for AI technologies, and it sets out a kind of cascading array of rules that would apply depending on whether the proposed AI technology would fall within a high risk category or a minimal risk category. And that's because, similar to what I was talking about, the sort of spectrum of technologies out there, some technologies are truly non-risky. They're sort of the basic word processing tools that we all come to know and rely on heavily, and they don't have any meaningful nexus to potential human rights impacts. So this creation of sort of a categorization scheme of risk is not a first within this draft. There's other models that do exist out there that are applicable to AI policy that also have a risk categorization structure. So one example in Canada is that all federal government departments who use AI programs have to comply with a directive that's applicable to all uses of AI at the federal level. And there's a number of risk categories with accompanying rules depending on that increase in severity depending on the level of risk at stake. Similarly, there is a draft policy that the European Union Parliament has put forward earlier in 2021, where you have a categorization structure with an accompanying set of rules that apply to each of the categories. And I think one of the important things to understand about that structure is that it can be very promising, and that what it can do is it can help move away from essentially a game of whack-a-mole, where you essentially wind up retroactively having a sort of endless series of new technologies that come into the scene, and that you deal with them in hindsight after lessons have been learned, after they've been used for a number of categories, a number of years, and they're being challenged for the first time in court by individuals who've been affected by them years after they've been introduced at a broad level. And so one of the problems in charter and human rights practice in Canada that we've seen in the justice system is often that you have sort of a piecemeal recognition of human rights rules that apply to very specific types of technologies. And then when it comes to new technologies that are modified in some technological way, but are similar in principle to the human rights risks that are at stake when these rules are imposed by the courts retroactively, that there in practice seems to be not sufficient linkage between the lessons that have been learned with respect to other technologies and applying them more proactively to the next technology that comes onto the scene. And that is a completely suboptimal way to go about the regulation of technologies used by police services, because there will always be new modifications. We need a set of rules that will work ahead of time as opposed to retroactively. And so by creating risk categories, it can result in the proactive identification of patterns such that you could foreseeably have a set of rules that provides guidance ahead of time, and some of those human rights risks are prevented. What we've recommended, building on that risk categorization structure, though, is that structure be improved upon in a couple of ways that we've identified in the submission. Firstly, we recommended that there be a prerequisite requirement that all AI systems meet minimum prerequisites of reliability, necessity, and proportionality. And so by setting a common and principled goalpost, it makes it very clear what each technology should be measured against, and sort of the principled prerequisites that human rights and AI researchers have identified as being a common theme to prevent against human rights risks. And we've also said that in creating the different types of risk categories, we recommend that those categories be made broader, and that they create the proactive identification of certain types of risk. Because right now, as the draft policy is presently worded, while you do have different types of categories, they're largely illustrated by giving examples. So in that regard, it's sort of somewhere in between the whack-a-mole model, which I've talked about as being suboptimal, and the idea of creating a recognized set of risks that can be common and analogizable between technologies without focusing too much on their nitty-gritty specifications. So rather than looking only at hypothetical types of technologies that would fall into the risk categories, we've drawn on some of the other models, such as in the EU, which uses factors such as the potential for that technology to impact upon a human rights protected interest. So the more proximate the technology will be to human rights protected interests, like equality, like privacy, like liberty, the risk level of that technology must go up inherently. Similarly, one of the important factors that is included in the EU model, which I think that we've submitted should be incorporated here in the Toronto draft policy, is that recognizing where there's a potential for a power imbalance to exist between the police service and the individuals and communities who are likely to be affected by the technology. If they're the greater extent of that power imbalance, it should be identified as a risk factor. Similarly, if individuals and communities are unable to opt out of being assessed by that AI, it includes that again increases an access to justice issue. And so that is a sort of one of the areas of reform that we recommended be adopted, so that that risk categorization structure has a greater potential to be a meaningful guard against human rights dangers before they happen. One of the a related set of submissions, and certainly I think there's about over 30 specific recommendations that are present in LEAF's and LAB's joint submission to the boards, to the drafters of this policy. I won't go through all of them in detail, but I'll continue to talk about some of the groupings of these recommendations. One of the major risk factors that we've seen in real life examples where these technologies have been used abroad is that a lack of training and resources within police services is a inherent risk factor. This is in part because AI itself is a very complex and interdisciplinary realm. And human rights as well is. And if the humans that are using the technology do not have the training, resources, and expertise to be able to identify and prevent those risks, then that gapage between the complexity of the regulatory sphere and the individuals who are operating within it will inherently be a major source of risk. And so another set of recommendations that we've included in our submission is that we've recommended that the draft policy ensure that expertise in independent vetting, risk analysis, and human rights impact analysis be brought right into the risk assessment stage of each technology that may be put forward in the future. And so there is a component of the draft policy that does recommend that there be consultation with experts, but it's more at the level of creating the set of procedures that the chief of police will follow when assessing these technologies. And we've recommended that actually be incorporated directly into the technology specific assessments that this draft policy contemplates, because of the inherent complexity and interdisciplinarity of these this range and world of technology that is out there. And so in terms of the types of expertise, that would include expertise in data processing, computer systems, AI, equality, community impacts and experiences. All of those are part of that range of intersectional perspectives and interdisciplinary perspectives that would enable more fulsome assessments of the potential implications of the technologies that may be used or considered. Requiring that be specifically adopted is in recognition that capacity and training and expertise is simply not part of the institutional analysis that would occur within the service. A very similar set of recommendations that we've also included zeroes in on the oversight and maintenance structures that would foreseeably be put in place, or that the draft contemplates would be put in place if technologies are going to be adopted. And so the present draft of the policy would require that high and medium risk technologies be reviewed by the chief of police every 5 years for analysis of whether or not the technology should still be used. But even within that 5-year incremental review process, the draft policy only requires that the indicators that would be tracked through that review process only be tracked for 12 months after a technology is deployed. And so you have this gap inherently within the draft between what type of information is being gathered for a time limit of 12 months, and then a review process doesn't happen until another 4 years go by. And so we've recommended that the scheme be reformed in a number of ways regarding maintenance, oversight, and auditing. Firstly, we've urged the Toronto Police Services Board to recognize that all high and medium risk AI technologies would need to be monitored ongoingly and indefinitely. I think that the simplest way to explain this submission is that you have to think of it as a cost of doing business. And going back to that topic of resource limitations within the services that do appear interested or are using these technologies in Canada, we've urged recognition that if AI technologies are going to be used, that must happen with a concurrent acceptance of full responsibility to properly maintain those systems from a human rights perspective. And so we've urged for adoption of expert consultation in how often that particular AI system will need to be reviewed, how it needs to be monitored and tracked in order to prevent error rates and bias from increasing over time as a form of drift, for example. And it's very likely that that expert consultation would result in a recommendation that more frequent and robust assessments that would be required than the presently drafted 5-year incremental period. If you kind of think about our car ownership as a poor example, it would be quite difficult to imagine the idea of thinking that you could only review and maintain your car once every 5 years, and AI systems are even more complicated. Some of the other types of examples of where we've spotted the need for added rigor into the oversight and accountability structures. We've urged for adoption of statistical tracking and formal documentation requirements, so that when these review and maintenance and audit systems happen, you actually have data and documentation to review. It's a very basic, a basic proposition, but if it's not made a formal requirement, you can see meaningful gaps. To return to the example of the Vancouver Police Department's predictive policing program, one of the stated positions of the service is that there is no indication of bias with respect to the use of that program. However, it's only much more recently been the case that the Vancouver Police Department has been required to document and maintain data with respect to the use of carding practices. And so it's more correct to think of it as an unknown about the extent to which that neighborhood focused predictive policing program has caused increased police scrutiny and bias in the communities that have come under increased scrutiny through algorithmic predictions. And that's simply a lack of data about that potential for bias. We've recommended regular and independent auditing through independent auditors is another form of really important and recognized within other areas and industries that have adopted AI as being an important check on the use of these systems, as well as public annual reports from the board about for example, unintended consequences that may have started to crop up as these new technologies have been experimented with or used. And I think it's important, after kind of reviewing some of those accountability and oversight focused recommendations, that the conversation about recommendations started with the recommendation about mandatory prerequisites about reliability, necessity, and proportionality. And from the research that we've done through the to surveil and predict report, it has been identified to be the case, that there are potentially many types of algorithmic policing technologies that are simply too dangerous as far as what we've seen in practice and what we know about human rights law. It's very difficult to understand and likely impossible for certain types of uses of technology to be used in a way that complies with human rights law. So there are really important questions that need to be answered before you even get out of the gate with certain technologies. But those accountability focused recommendations that I just reviewed are all made on the assumption that some technologies make it past what need to be really preemptive and rigorous threshold screening for prerequisites about proportionality, reliability, and necessity. Some of the other recommendations in the submission, which again, I won't go to all of them because there's just not enough time for today. There's a number of recommendations that hone in on what we identify to be a lack of clarity and lack of sufficient protection against mass surveillance activities. For example, pinpointing the need to recognize that both covert and overt forms of mass surveillance are extreme risk. We also have urged limiting language around mass collection of data in and of itself, as opposed to surveillance and monitoring per se. And so it really enhancing the clarity of the language that would put meaningful checks on the potential that technology has to facilitate mass data collection, surveillance, and monitoring, which would be inherently disproportionate if used in the way that some private sectors in this space are seeking to advertise and sell to police services. Another one of the takeaway recommendations or sets of recommendations is a couple of areas to focus on the risks that are engendered where a police service essentially contracts with a private enterprise who's seeking to profit off the use of policing technology by getting into a contract for service with a public institution like a police service. So there's recommendations focused on that. But what I would say is a couple of points to conclude the more formal part of our presentation, which is before we get to questions today. Just talking about the broader landscape in which the draft policy exists within. Since the Surveil and Predict report was published in 2020, we've seen a number of initiatives across Canada regarding the regulatory structure that would exist around potential uses that we may not know about or that we already know about of algorithmic policing technology in Canada. And so one of the thorny issues that we wrestled with as researchers in producing that report is thinking about what is the ideal form of regulation when it comes to risky technologies such as those used by police services. And one of the particular challenges in Canada within its system of government is that police services exist in a number of different formats, both at the city level, national level, provincial or regional level. And the regulatory landscape is inordinately complex and complicated. And if there's no one government body that is a regulator to all. And compounding that complexity is the topic of AI and human rights itself, which, as I've talked about earlier, is a very interdisciplinary and complex space, an important one given the human rights risks that are quite imminent or on the horizon. And so but what we do see, nevertheless, despite it being a very diffuse collective action problem between government bodies at a number of levels, there are initiatives that we're starting to see. For example, perhaps in talking about Toronto, I'll focus on the Information and Privacy Commissioner of Ontario. They've published a policy document which has identified its strategic priorities over the next 4 years. Next generation law enforcement technology is one of the priorities that it has identified as being a strategic priority for the commissioner in Ontario. And that goes to show that this draft policy, while at a board level, it's a very important mechanism for regulatory oversight. And in fact, in our country's tradition, boards have become one of the most important venues for oversight of police services because of a trend that has persisted throughout law reform to give independence towards police services. Boards are a very important mechanism for oversight of services as it has developed in Canada. But nevertheless, to the extent that other initiatives by privacy commissioners, human rights commissioners, provincial governments, federal governments introduce rules and regulations, obviously each service would have to comply with the highest bar that is set. There's privacy legislation reform going on in Canada in a number of different regions, and a potential that some of the very vague and discretionary provisions that come to personal information used by law enforcement may be amended. And we've seen as well at a collaborative scale, privacy commissioners across the country considering the issue of what guidelines are needed on the use of facial recognition, filling in a legislative void in this area. And so what is important, again, is stepping back in looking at the role of this draft within this larger regulatory or potential regulatory landscape, is that regulation has a role, but it goes as a more proactive mechanism of enforcing the charter rights and the international human rights that apply regardless of what those regulations look like. And the whack-a-mole game that does exist in the justice system is suboptimal, but at the same time, it's important to recognize that these rights already exist now and they restrain government action now. And so when we think about what regulations are needed, it's more about making those rights more meaningful in reality and moving from theory to practice. And what I would also urge researchers and individuals who are listening to this conversation and considering this policy to think about the humanity of this policy issue. And as someone that has practiced in the justice system for several years now, what I have identified as a need is a culture of humility within institutions that seek to embark on experimentation with this technology, because it can unfortunately be the case where you can be left in a situation where at an individual level, people who work within institutions that are involved in the enforcement or compliance of human rights law, whether it's within police services or courts or other government agencies, at an individual level, I know from experience and in conversations that we individually all struggle to understand and grapple with the complexity of this issue. It's an inherently interdisciplinary issue. So even myself, I will struggle as a researcher to opine on issues that are very deeply involved in computer science because I don't have that background. And so individually, we can all feel quite insecure about how we participate in the larger process that may be underway that we're considering expanding, possibly in Canada, despite the risks on the horizon. But when it comes to the institutional reality in courts, if we were to address these issues retroactively in court, individuals who are left with the burden of accessing human rights protections through litigation and court process face a number of hurdles that if you haven't experienced the justice system, you wouldn't necessarily anticipate to be quite so difficult. And so when I talk about that as a risk factor, the power imbalance between communities who are affected by technologies and the institutions that would seek to use them, I really emphasize that is a factor that shouldn't be underestimated because We think and have a lot to be proud of in Canada about how we have a system in our justice system that it revolves around the right to a fair trial, but it still struggles to make principles meaningful and accessible on the ground. And it's certainly something that the defense bar, for example, struggles with till to this day to be able to meaningfully access the rights that are in existence, but you still need to do the work to make them meaningful for individuals and communities. So I'll leave it there. And unless Suzie, you want to add anything further, we can turn it over to questions.